Welcome to ADI Pune Design Mixer. This is our welcome new members of ADI Pune. We have a lot of new members happening last week. So this is Raghvendra. I am a part of newly elected ADI team, and this is our first online event and second ADI Pune Mixer. Before I explain the concept of Mixer, I would like to introduce ADI to our new members. Most of them are aware ADI through PDF, but ADI is a network of design professional industries, students and educational institutes in India. ADI is also a community of exceptionally skilled, extremely diverse and designers across domains. And we aim to create a meaningful interface with industry, academia, users and policymakers. ADI Pune is one of the most vibrant chapters of Association of Designers of India. And I think last month we started this concept of online mixer, obviously because we can't meet and socialize and can't party together. So this was a little casual event where social sharing will be possible. To make it more interesting and different, we thought of taking up non-design topics. Last time we discussed something about finance. Today we are going to talk about intellectual property, and Raghvendra is already here for that. He'll be giving you a brief talk and presentation, and then we can go ahead with Q&A and then some informal chat. I would like Nishma to introduce our guest and start today's design mixer. Over to you, Nishma.
Thank you, Raghvendra. So I'd like to welcome Raghvendra and also thank him for taking his time out today to be present for this mixer. So Raghvendra already explained the concept of this mixer, and we hope to have a good chit-chat session with him and discuss about the very important aspect of intellectual property that most of us designers deal with in day and out. So Raghvendra is a managing partner at Pune Ponkshe, and he's a IP consultant. And we have known Raghvendra because we work together, and he has helped us with filing of patents and protecting our intellectual property. And I'm sure some of other people here might also have worked with him, or maybe our clients have also worked with him. So it's been a nice interaction, and so we thought that let us chat with him and see what he can help us with. So I hand this over to you, Raghvendra. He's going to show us a few slides. He'll be sharing his screen and show us talk about some cases to explain the different concepts that are there. Over to you, Raghvendra.
Thank you, Nishma. Thank you, Raghvendra. Thank you for having me here. I'm going to talk about the basics of intellectual property, as it's a lot of misconceptions about what intellectual property stands for. So kind of a very short presentation, not the elaborate one, as IP takes a long time to explain. I've tried to kind of concise it and make it short so that we can utilize the time more during question and answers, if you have any.
Oh, we have many, I'm sure.
Yeah, sure. Yeah. So, is it visible?
Yes, yes.
Before I start, I would just take a few seconds in introducing who we are. Pune Mixer was established in 1965 by Satyar Ponkshe and Madhav Bhate, both entrepreneurs and inventors in their own right. Incidentally, before Mr. Ponkshe came down to Pune, that is in 1964, he had 20 patents in his name. And the first patent in our family was filed pre-independence and was granted before independence came to India. So before it was granted in 1946. So the patent and intellectual property thing kind of runs in our blood, as we had patents before intellectual property, before the independence of India. And since 1965, for the last 55 years, we have been helping a lot of national and international clientele for securing their intellectual property in India as well as in almost 120 countries across the world. We filed more than 5,000 patents and 5,000 trademarks for our clients in India and globally. And the team typically is technical and legal expertise, has technical and legal expertise as is desired, because patent essentially is a technical domain kind of activity. So is design, and trademarks and copyrights go more towards the legality aspect. So that is who we are essentially. Straight getting into the topic, there are two types of properties that we typically look at. The tangible properties, that is land, building, machinery, computers, vehicles, everything that can be touched, viewed, felt per se. And the intangible ones, which cannot be touched or viewed, which is termed as intellectual property. Anything which comes out of the human mind is intellectual property, as they say. This is my favorite line. IPR is a boring subject until it costs you money. I've come across many people when I meet clients, when I interact with students, innovators, large corporates, MSME people. They come to me and they say, I would want to protect something. Now, the first question is, I ask them, why now? So have you developed it today? The answer is no. And they tell me that, they had developed a product, they had developed a business, a brand, and which was put to use for, say, a couple of years. And now they see in the market that people are stealing their product. They're stealing the concept, they're stealing the idea. And that is why they want to now protect it. So eventually what I tell them is, because your ignorance has cost you money, right? Because you have not protected yourself well through the various facets of intellectual property, it has actually cost you a lot of money. Today, if you look at it around yourself, you'll see a lot of deals happening, a lot of venture capital deals, a lot of private equity deals. And all these deals, there is a component of intellectual property involved. The first question that when they take the due diligence path, they would ask you for your intellectual property portfolio. And they would want to value that intellectual property portfolio. If you don't have intellectual property portfolio, then the valuation definitely is a hit, right? It doesn't give you the kind of valuation that ideally it should be if you had some intellectual property created or an IP portfolio created. So essentially, though it's a boring and a legal topic, it definitely costs you money. So you need to be careful when you're dealing with intellectual property rights. So then what is intellectual property? It essentially is creation of human mind or intellect, which could be an invention or innovation, symbol or names and logos, literary and artistic works, shapes and design. I firmly believe there's nothing called as invention anymore. They're all innovations, right? Because we look at a problem and we find a solution. We look at a good to have thing and we try and strive to make a design or a system or a construction which could address that problem statement for that matter. So that is what intellectual property is all about. I'm going to briefly run through a case study which could kind of cover all the facets of intellectual property. This is something which we use 365 days, almost 24/7 for some who are working day and night, right? And it's something which is part of our life. Do we have intellectual property here? A very basic stuff. I'm not getting into all those design aspects that, because you are designers, you know what design is all about. But I'm just trying to kind of get through what IP kind of consists out here. So when you look at this bottle, do we see any intellectual property here? When you look at this photograph, as I would say, do we see any intellectual property here? Let me look at the first facet. The packaging, the label, which is associated with the product, is a subject matter of a copyright. Anything which is artistic and literary in nature, which has a unique composition, a unique representation of sorts, is a subject matter of copyright. You have all these fancy packaging which is developed by designers like you, right? All these packagings, all these colorful packagings are all a subject matter of copyright. For example, a very localized example, if you go into a Kirana shop and you see a blue bottle, what would you call it? What would you relate it to? It's a color. You see a blue bottle out there. It's a packaging. In our parlance, we call it as trade dress. You're dressing a product for the trade, right? So the packaging has importance for any product. So what does that blue bottle signify? it signifies a product called parachute, coconut oil. You won't call that blue bottle a Coca-Cola, or you won't call that blue bottle a Pepsi. Right? You would always relate that blue bottle to Coca-Cola because of the trade dress, because of the unique color combination, or the color or the label which is seen on that blue bottle. Right? So copyright essentially is given for any artistic and literary work, whether used in trade and commerce or otherwise. Packaging is a subject matter of copyright. Trademarks, another facet of intellectual property right. Any brand which is used in trade and commerce is a subject matter of a trademark. Here, in this instance, you can see Nescafe, you can see Gold Blend, which is a registered trademark of Nescafe. And all the other marks which are there on the label, on the bottle, are also registered by Nescafe as being their brands. Now, what does trademark signify? It signifies the origin of a product, where the product comes from. Now, if I talk about Bakarwadi, a very typical Pune example, will we call it a Haldiram Bakarwadi? We will always kind of connect it to Chitale Bandhu Mithai Wale. Why? Because we know that a good quality Bakarwadi will always come from Chitale Bandhu Mithai Wale. So the source of origin is always associated with a product. And that association comes from a trade name, from a trademark, right? From a brand. So brand is protected by way of Trademarks Act. Design rights, something which is very dear to you, all of you out here. So what are design rights? What is a registered design? Design is given for a shape of an object which is visible to the naked eye. A unique novel shape, the aesthetics, the configuration of the product, which is novel in nature and which is unique in nature and which is visible to the naked eye, is registered as a design. Here in this instance, you can see the unique shape of the bottle of Nescafe. Now that unique shape of that bottle is a subject matter of design. Any unique shape, you look at any shape of a car or of a mobile, or even the mouse for that matter, the mouse that we use regularly, the multiple mouse designs that you see today. All these unique designs are subject matter of design registration. In the America, it is called as design patent, but in the rest of the world, it is called as design registration. Now, the second example here in this image is the cap. Now, the cap also has a unique design. Now, that design of a cap, the structure of the cap, the design, the lines on the cap also form as a design element. Now, that design element also is captured under the Designs Act. The bottom also, the entire shape and configuration is considered to be unique in nature and is hence considered to be design registrable. And finally, the most important aspect of intellectual property right, which is generically called patents. So you don't need to be an Edison to file a patent, number one. You don't need to be a great inventor to file a patent. As I said earlier in my opening remarks, it is innovation that is happening today. So here in this instance, the process of making the bottle, if it is unique, it could be a subject matter of a patent. The machinery which is manufacturing the bottle, if it's unique, it can be a subject matter of a patent. The other image that you see is of the sealing, the seal on top of the bottle, right? The process of sealing the bottle could also be a subject matter of a patent. The machine used for sealing the bottle could also be a subject matter of a patent. If there is a sealant used for sealing the bottle, that sealant, if it has unique composition per se, could also be a subject matter of a patent. So it need not be something which is out of the world. Any improvement in any technical stuff could be a subject matter of a patent. You also see an image of the cap out here. Now you could also see a locking mechanism in the cap. That locking mechanism of the cap could also be a subject matter of a patent. Right? So it encompasses everything in a single product per se. Right? And finally, it comes to the coffee granules. Now, the process of making those granules, the machinery of making those granules, the composition of the granules, right? All these things could also be a subject matter of a patent. So if I look at one single bottle, one single product, it actually encompasses all the facets of intellectual property right. You talk about copyrights, you talk about trademarks, you talk about design registration, you consider patents. Everything can be looked at when you look at a single object, which is unique in nature, right? So everything that we see today has an element of intellectual property in it. So let me take you quickly to through the IPR facets. What is a patent? What are the criteria for patentability? The first criteria and foremost criteria for patentability is novelty. So because everyone says they've done something novel, they say that they have done something unique. But then what is novelty defined as? Across the world, the novelty is defined as whatever you're trying to claim as novel should not be in the public domain anywhere across the world before the date of filing of your patent application. Now, many a times we come across people, clients, who come to us and say that we would want to patent an XYZ product. Now, my first question to them is have you got some inspiration from somewhere? Because that's always my question to clients, to find out where they've got this inspiration from, how they've improved that. Now, sometimes people are blunt in telling me that they've got some inspiration. Sometimes people don't want to tell us where they've got the inspiration from. Sometimes people also tell us that this product is available in the US, this product is available in China, this product is available in Singapore, but I want to file a patent in India. Can I get a patent? My answer to them is no. You can't get a patent on that because it is already available in the public domain. It can be imported and sold. So you cannot get protection for something or on something which is already available in the public domain commercially. So novelty is the basic criteria of patentability. The second criteria, which actually is a very thin line, is non-obviousness. Non-obvious is defined as it should not be obvious next technical step, or it should not be obvious to a person skilled in the art. Now, for me, it could be obvious, and for you, it could be non-obvious. So obvious is always a very, very thin line, but we have to fight in almost 80% of the cases to distinguish and define how it is non-obvious, right? To cite an example out here, people, if I'm looking at a mechanical process and I say I have automated the process, now claiming that I've simply automated a process which is mechanical in nature is termed as obvious. It's an obvious next technical step, right? But how I have automated that, what is that? What are the elements of automation? Whether I've improved the automation, whether I've done some constructional activities while I'm automating, or whether I've created a new system for automation, whether I've improved the system of automation, that could be a subject matter for patent because that then will not be construed as a next technical step, right? And the third basic criteria of patentability again is utility. A mere abstract idea which has no utility cannot be a subject matter of a patent. Everything that you want to file for a patent has to have industrial applicability or has to have utility per se. If it does not have utility, it is not a subject matter of a patent. Now, there are many other facets of non-patentability. Just to cite a few, a new application of a known device or a new application of a known process is not a subject matter of a patent. It's actually a discovery. And discoveries do not fall into the scope of patentability. You have discovered a new use of a product or a new use of a process. Hence, it is not a subject matter of a patent. Mere admixture of known things, which do not give any added technical effect, is not a subject matter of a patent. A good example, a very simplistic example, is the process of making tea. You have water, you add tea leaves, and you add sugar, and you add milk. What they do actually is they work why they are added for. The tea leaves give you the aroma and the flavor. Milk obviously gives you the milk effect. Water is the liquid and sugar is the sweetener. So they are not giving you any added effect. They are merely doing what they're supposed to do. Now, such admixtures, mere admixtures, do not fall in the scope of patentability. The method of agriculture and horticulture does not fall into the scope of patentability. Computer software per se does not fall into the scope of patentability. But if it is a combination of hardware and software, then yes, it may fall into the scope of patentability. Medical prescriptions, presentations, do not fall into the scope of patentability, as well as atomic energy related applications do not fall into the scope of patentability. Then what can be patented? The subject matters are any machines, any systems, any processes, any methods, any articles of manufacture, any chemicals or substances or combinations or compositions, any biotechnology related compositions which are novel, non-obvious, and have utility would sustain the patentability criteria and can be a subject matter of a patent. What is looking at industrial design, which I'm sure is very much related to what you people do. Industrial design is given for any novel aesthetic aspect of an article, which is a shape, which could be a configuration, which could be a pattern, which could be an ornament, composition of lines, which are applied in 2-dimensional or 3-dimensional forms. All your products that you create, which are unique in nature, which have unique aesthetics, unique shape, unique configuration, could be a subject matter of design. A good pattern design could be, Solapuri chadar. The patterns that you get on Solapuri chadars or Paithani sarees also are a subject matter of design, so to say, because Solapuri chadars have almost been all design registered by the manufacturers of Solapuri chadars. Right? So all these forms, ornaments, all your jewelry items, all of them are subject matter of design registration. Trademarks, as I mentioned to you, could be any word, any logo, any numeral, any sign, any signature, tune, device, which could be an invented word, which is non-descriptive in nature. People typically tend to create descriptive marks because they would want to associate the buyers with a descriptive mark. For us, it is a bad mark. How we term it is a diluted mark. If you look around yourself, you will find at least 1,000 Balaji stores. If you look around yourself, you will find 1,000 Lakshmi stores. If you go to Lonavala, you will find at least 100 A1 stores or Supreme or Super stores. All these are very descriptive. They denote the character of the goods and services for that matter. So such descriptive, which denote the character of the goods, are considered to be bad trademarks. Anything which is invented, anything which is coined is a good trademark. An example that I would cite here is a brand called Sanikova. One of my clients coming from Karad came to me to register a brand called Sanikova. My first question to him was, what is the market that you're looking at? He told me he's looking at Dubai, Middle East, and the Eurasian market, which is Russia and the erstwhile USSR. And that's the reason I thought he had come out with this name, Sanikova. It was a non-descriptive mark. I said, it's a great mark. But then I asked him, how did you come out with this brand? The simple answer that he gave me, it is a combination of Sania Mirza and Anna Kournikova, because he was a tennis buff. Right? So it's a coined word. It's an invented word, so to say. So if you look around you, you will find a lot of coined words, non-descriptive words, a lot of invented words. And such words are good trademarks, as I would put it. Again, important aspect of a trademark is easy to pronounce. I'm getting into your field, but this is what we look at from a trademark and a goodwill perspective when we go into valuing the goodwill of a trademark as well. Now, we have so many examples in the automotive industry where the automotive industry has come out with certain brands which have worked in a particular geography and have not worked in a particular geography, because the connotation of that word is completely different in a particular geography. You have such examples in India also. You have such examples in Pune also, where people have taken up French names like Gautier. It was a failure, as I would say, because they had to change the brand after a few years, because people could not pronounce that brand because it's a French word, right? People have difficulty in pronouncing these words. So it should be easy to pronounce. And again, as an advice, consider the market before deciding a mark, because that helps when you're coming out and when you're making a mark which can generate goodwill and which could get you registration all across the world. Copyright. Copyright is given for any original work or representation, which could be literary, dramatic, musical work, artistic work, cinema, film, sound recording, computer software, UI, UX, and engineering drawings. All these are subject matter for copyright. All your books, all your user manual that you create can be considered as literary in nature, or the artistic combinations that you create are subject matter of copyright. All the UI, UX that you create for your clients is a subject matter of design, or the architectural work, or the engineering drawings that you're creating, all the sound recordings, musical works that you create for your clients is a subject matter of copyright. So all in all, if you look at it, every product, every service, IP is a facet out there. Some facet of intellectual property can give you protection of whatever creation that you make, whatever original work that you do can get you intellectual property right, can secure you an intellectual property right. So what is the coverage of intellectual property? You must have heard people telling that I have a global patent, I have a global trademark, I have a global design. It's a misconception. There is nothing called as a global patent. There is nothing called as a global trademark. There's nothing called as a global design. Patent, trademark, and design are essentially territorial rights, which means that a patent, trademark, and design granted in India is only limited to the geographical territory of India. It is not valid in even the Bangladesh or Sri Lanka. Likewise, a US patent or a US trademark or a US design is not valid in Mexico or Canada. It is limited only to the United States of America. Patent has a definite life. The life is for 20 years. You cannot renew a patent beyond the life of 20 years. It gets into the public domain after the life of 20 years. Patent has to be renewed every year. If you don't renew the patent which is granted to you in a particular geography, the patent lapses, it is called abandoned, and any party, any interested party can start using that patent. Trademark likewise has a 10-year life, which can be renewed every 10 years for perpetuity. For example, Bhate & Ponkshe is a trademark which is there for 50 years now. So we have renewing a trademark, our trademark every 50 years, right? And that's how we have kept it registered in perpetuity. Copyright is the only right which is international in nature, because India has signed the Berne Convention, has acceded to the Berne Convention. Berne Convention has been acceded by more than 100 countries. That makes our copyright application in India go international. So this is the only right under the intellectual property which can give you international protection per se. The term of copyright, as we call it, is the life of the author plus 60 years. So almost it's like perpetuity, right? If everyone lives for say 70, 75 years, after that, it can still sustain 60 years more, and the licensing revenue or the publishing revenue or whatever revenue you are looking at from a particular copyright work can be there for a life of the author plus 60 years. Design, as I've mentioned, is for 10 years plus 5 years. That is 15 years in totality, cannot be renewed more than 15 years per se. So every IP right has a life, has an enforcement restriction. So as we say in our intellectual property parlance, in patents, novelty is global, enforceability is local. All the rights are territorial in nature. So if you are not registered in a particular territory, you do not have a right in that particular territory to enforce for any infringement. So it is always better that if you're looking at any international commercialization of any of your intellectual property, you should look at registering or securing those rights in that particular country or geography. Otherwise, you're open, you're gullible. People can make infringement, can sell your products, can use your brand, and you won't be able to stop them. So then what is the use of IPR? The simple answer, it adds value. It gives you market leadership through monopolistic rights, and it gives you competitive advantage. Now, there are multiple ways that IPRs can be commercialized. It can be licensed to multiple people. It could also be sold, assignment of rights as we call it. It's like any property that you possess, right? If you have an apartment, you can give that apartment of leave and license. You can sell that apartment. The same thing happens with the intellectual property rights. You can license the rights, you can assign the rights. IPs are used in as leverage in deals and mergers. There's a lot of cross licensing that happens. People buy IP rights, people buy IP portfolios. For example, Motorola IP portfolio was bought by Google. Nokia was bought by Microsoft. Uber, a company like Uber, who has about 2,000 patent applications, keeps on buying patents or copyrights from different geographies to kind of enhance their IP portfolio. So people keep on looking at different IP rights and try and enhance their portfolio and keep on buying acquisition of IP rights, as we call it, which is used as a leverage in deals and mergers. And fundamentally, it also reduces the risk of infringement sued by competitors. You hear a lot of stories, you heard a lot of cases which are happening these days. IP litigation is going to grow in our country. As I was mentioning before we started, if you look at the Indian figures, if we are filing, say, 50,000 applications with the Indian Patent Office every year, 80% of those applications are filed by international companies in India. 20% are filed by Indian inventors. That's a very less number, right? So we are looking at a lot of litigation coming in the future. Either we grow and we file more applications, we secure our own turf, or we are left with receiving a lot of litigations and infringement notices in the future. If you look at trademarks per se, there could be about 40 lakh trademarks already registered in this country. How many of those are by Indians? And how many, if you look at the balance, you would see a lot of big portfolios by large international companies secured in India. I always advise people that, if you come out with a unique name, go and register it. You will at least have a chance to use it. When we do search today for our clients to find out whether a trademark is available, the availability of a trademark is getting lesser. We are not finding good names which are available today. People have to really fight hard to find a good name, a good invented and coined name, which could be registered in India, also globally if they're looking at a global business scenario. So it is going to be very difficult in the future to find the right name, to find a name could be registered which you can own. Similarly, we are looking at design infringements happening today. We're looking at design litigations happening. Small, things like toys for kids have been litigated today from a design aspect. And these things are going to grow. So it is always essential to protect your intellectual property rights, whichever way they are, whichever facet they are of IP. So that could be used for the future, could be used for generating a lot of revenue and licensing. Thank you.